Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the Deep Dive. Today we're plunging headfirst into a legal battle so unusual, it honestly sounds like pure science fiction. Imagine an invention called the Necktie Persona-Extender Environment-integrator and method for super-augmenting a persona to manifest a Pan-Environment Super-Cyborg.
Wow.
Seriously, what does that even mean? It certainly got our attention.
Yeah, you read that title and you just have to know more, don't you?
Exactly. So our mission in this deep dive is to unpack the wild journey of this truly beyond AI invention through the Indian patent system. We're going to explore the fascinating and, let's be honest, sometimes baffling arguments made by both the visionary inventor and the scrutinizing patent office, and then, of course, the court's ultimate decision. This is your shortcut to understanding a really cutting-edge legal case where innovation pushes the absolute limits of imagination.
And then slimes right into the hard realities of intellectual property law. It's quite a collision.
Okay, let's unpack this then.
That's right. While a patent case might, sound a bit dry on the surface, as you'll quickly discover, this one is anything but. It genuinely features a super cyborg and a necktie persona-extender, making it kind of a unique entry in legal history.
So before we get too deep into the super cyborg details, let's maybe set the foundational scene for this legal deep dive. Where and when did all this actually go down?
Okay, the core identifying details. This was case number CMA PT 92 of 2024. It was heard at the High Court of Judicature at Madras in India.
Right.
And the judgment itself was pronounced on January 29th, 2025. This wrapped up a process that had actually been reserved for a few months, since September 24, 2024.
Okay, so fairly recent then.
Yeah. And the judge presiding was the Honorable Mr. Justice Senthil Kumar Ramamurthy.
And who are the actual players in this futuristic legal battle, the parties involved?
So on one side, you had the appellant, the inventor, Caleb Suresh Motupalli. And what's quite notable here, really, is that he chose to appear as party in person.
Meaning he represented himself.
Exactly. Represented himself throughout the whole proceedings. That's a significant commitment to his invention, you'd have to say.
Definitely. And the other side?
On the other side, the respondent, that was the patent authority, specifically the controller of patents representing the patent office in Chennai. And the controller's counsel was Mr. A.R. Sakthival, a special panel counsel.
Okay, here's where it gets really interesting. What exactly was this necktie persona-extender trying to achieve? What was the big idea? And, what was this winding path through the patent office before it even got to court?
Right. Well, the invention's grand vision was incredibly ambitious. It was titled, as you mentioned, Necktie Persona-Extender Environment-integrator and method for super-augmenting a persona to manifest a Pan-Environment Super-Cyborg. Its stated goal was to provide a beyond AI solution specifically to address something the inventor called an entropy.
An entropy. Okay, can you give us a quick sense of what that means?
Yeah.
It sounds complex.
Well, the inventor described an entropy as essentially the loss of human agency to AI, the idea that AI takes over too much. His solution aimed to non-invasively integrate human intelligence with AI, intending to, and this is a quote, upgrade humans to Human 2.0.
Human 2.0?
Yeah, allowing humans to regain control and augment their capabilities in what he saw as an increasingly AI-dominated world.
Wow, that's quite the upgrade. So what was the timeline for this ambitious vision's journey through the Indian patent system? It started way back, didn't it?
It did. The initial filing, that was Indian Patent Application NA 5606CHENP 2012, filed on June 27, 2012, but it was a national phase application stemming from an earlier international PCT and even a U.S. application dating back to 2009. So yeah, this idea had been percolating for quite a while.
Okay.
The first real official hurdle came with the first examination report, the FRR, which was issued in August 2018. So quite a delay there already.
Yeah, 6 years.
And this report flagged several issues. Concerns about inventive step, industrial applicability, and specifically highlighted non-patentability under some key sections of the Patents Act.
What kind of sections are we talking about here? What were the main sticking points?
Well, they raised objections under Section 3K for computer programs. That's a common hurdle for software inventions, right? They often need to show a tangible technical effect.
Right, not just an algorithm.
Exactly. And Section 3-mitter for mental acts, among others. There are also concerns about the sufficiency of disclosure, basically. Did he explain it well enough? That's Section 10.4, and the clarity of claims under Section 10.5.
Okay, that's a lot of complex legal ground right out of the gate.
Yeah.
How did the inventor respond to this first rejection?
Well, the appellant responded. He amended the claims, tried to clarify things. A hearing was held in September 2020, but the controller's original decision in April 2021 still maintained many of the objections. Lack of enablement, clarity, inventive step, citing prior art, basically saying others had done similar things.
So still a no.
Still a no. Feeling aggrieved, the appellant then filed a review petition in May 2021, making even more amendments. After a second hearing in July 2021, the controller issued the final impugned order, that's the one being appealed in October 2021, and again, rejected the application.
Wow.
This time, they cited even more prior art, D2 to D8 combined with D1, and they added a new objection under Section 3B.
What's Section 3B?
That relates to inventions contrary to morality or public order, so pretty serious objection, and they kept the issues with Sections 3K and 3-mitters. This October 2021 order was the one ultimately challenged in the High Court.
So we've got this visionary inventor, this super-cyborg concept, multiple patent office rejections. What were the core legal questions the High Court really had to untangle in this sci-fi-esque patent dispute? And how did the inventor and the patent office kind of butt heads on these points?
Right. So the court primarily needed to resolve two major questions. First, there was a really critical procedural point. Could the High Court even hear an appeal against the controller's review order under the Patents Act?
So a jurisdictional question first.
Exactly. A fundamental gatekeeping question. Was this even the right place for this fight? Second, if the appeal was deemed maintainable, then the court had to dig into the merits of patentability, which meant scrutinizing whether the invention truly met the criteria for a patent, specifically looking at, sufficiency of disclosure, clarity and scope of claims, and critically, the patentability of computer-related inventions and mental acts. Sections 3K and 3-mitters again.
Okay, let's dive into the appellant's arguments first, the inventor's side. He had this grand vision, right? How did he try to explain it in a way the patent system could, grasp?
He certainly tried. On the issue of vagueness or sufficiency of disclosure, Section 10.4, which asks if you've described it clearly enough for someone else to make and use it, he argued that just because he used non-standard terms didn't automatically mean it was insufficient. He cited the big Novartis case, emphasizing that sufficiency should be assessed from the perspective of a person skilled in the art, or PSI.
Right, the PSI. And what exactly is that? Is it just one person or?
Well, a PSI is basically this hypothetical expert in the relevant field, the person who'd try to implement the invention based on the patent description. But the inventor, referencing another case, in Renakian, actually contended that for an interdisciplinary invention like his, you'd need a whole team of PSI.
A team?
Yeah, because no single person could possibly be skilled in all the diverse arts involved. AI, maybe hardware, maybe sociology, who knows? He argued his specification was adequate if individual experts in their respective fields could just work on their relevant parts.
That's a bold claim. Asking for a team of experts just to understand one patent. What about the clarity and scope of his claims, how he actually defined what he'd invented?
For claims clarity and scope, that's sections 10.5 and 591, he argued that his main independent claims numbers 14, 20, and 25 were drafted in what's called the Jepson format.
Okay, what's that?
It's a common structure in patent law. It clearly sets out the known prior art first, and then explicitly states the novel improvement your invention adds. He said their length and complexity were simply justified by how multifaceted the invention was. And he maintained the amendments he made were purely for clarity, not to improperly broaden the scope.
He also brought up the best mode and inventive step. This is where those more abstract concepts came into play, right? The really unique stuff.
Exactly. Regarding the best mode of performing the invention, Section 10.4b, which requires inventors to disclose the best way they know to carry out their invention, the appellant pointed to claims 19, 24, and 30. These describe something he called the Christocratic Necked Service-Oriented Architecture, or CNSOA. That was his best mode.
Yeah, what was that? It sounds unique.
It was indeed. This system, with its truly unique phrasing about the decussation of left and right flanks of the upright and inverted pyramids, It's incredibly abstract, drawing on your biblical and natural elements. He claimed this offered a unique technical advancement, facilitating non-invasive human-AI integration, physical goods integration, and integrating the real world or meat space into cyberspace via something he termed labor space.
Labor space.
Yeah, which he argued was completely absent from any prior art.
Okay. And how did he try to tackle those tricky Section 3 objections, particularly 3K, about computer programs and 3-meter about mental acts? Those seem like major hurdles for this kind of idea.
Well, for Section 3K, the computer-related inventions part, he relied heavily on the Farid-Alani case and the official CRI guidelines from 2017. He argued his invention absolutely met the technical effect test. That's the key thing, right? Software needs to show a tangible impact on hardware or real-world technical improvement, not just be an abstract algorithm.
Right.
He stated that his black box modernizing structural features actually transformed the user-AI computer-object relationship. It provided a novel system with tangible real-world effects. He felt it co-opted AI to augment human cognitive and physical powers.
And the mental acts objection, Section 3 middle.
For that, he contended the invention involved really complex system interactions and physical implementations. It wasn't reducible to just, mere mental steps someone could do in their head.
Okay. And he had a procedural point, too, right?
Yeah.
About the morality objection.
Yeah, finally, he protested that the Section 3B objection, the one about being contrary to morality, was unfairly raised only during the review stage. He argued this denied him a proper chance to address it earlier in the process.
Okay. So, on one side, we have this vision of Human 2.0, a multidisciplinary team needed to understand it, very abstract concepts. Now, let's hear the counterpoints from the Patent Office. They clearly had a very different take on this invention's patentability.
Oh, absolutely. Their arguments were quite direct and really focused on those core patentability requirements. First off, they contended there was a clear lack of inventive step. They argued that the technical features claimed, both in the independent and dependent claims, just lacked inventiveness when you compared them to the existing technologies or prior art. They specifically mentioned combining D1 through D8.
So basically saying, we've seen bits and pieces of this before, and putting them together like this isn't a big enough leap.
Pretty much. They said prior art already disclosed methods for virtual environments, information retrieval, black box modernization, cognitive learning, things like that. The combination wasn't inventive enough in their view.
And what about the description itself, the language, the clarity, the sufficiency?
That was another major point for them. On grounds of insufficient disclosure and clarity, sections 10.4, 10.5, and 59.1, the Patent Office argued the complete specification just lacked adequate definition. They pointed specifically to the extensive use of, biblical references, undefined terms, and generally ambiguous phrases. They felt this broadened the claims way too much, beyond what was legally supportable, and ultimately failed the basic patentability criteria.
And the inventor's argument about needing a team of experts.
They weren't buying it. They emphasized that the interdisciplinary nature of the invention didn't excuse this lack of clarity or somehow make it eligible for patent protection if it wasn't properly explained.
Okay. And the Section 3K and 3-meter objections.
They stuck to their guns there, too. They asserted that the absence of a clear, defining set of computer-executed instructions or any demonstrable technical effect on hardware meant the invention was simply non-patentable under these sections. No clear software implementation, no patent.
Okay. So after hearing all these complex arguments from the super-cyborg vision to these very specific legal technicalities, what did the High Court ultimately decide? And crucially, what was their reasoning for this pretty unique case?
Well, the bottom line is the High Court dismissed the appeal.
Dismissed. Okay.
Yeah. They stated flatly that the controller's rejection order did not warrant any interference, meaning the Patent Office's decision stood. And no costs were awarded to either side.
So the Patent Office's decision was upheld. But what was the core reasoning behind that dismissal? Did they just agree with the Patent Office's arguments point by point?
Their reasoning was actually quite layered. It had two main pillars, starting with that critical procedural point we mentioned earlier. First, and this was kind of decisive on its own, they concluded that the appeal itself was not maintainable.
Back to the jurisdictional issue.
Exactly. The court noted the appeal was against an order in review issued by the controller. And crucially, the Patents Act clearly lists which specific orders can be appealed to the High Court under Section 117AA. Orders made under Section 17.1F, which covers reviews, are simply not on that list.
So legally, there was no pathway for this appeal.
Correct. There was no statutory right for the appellant to appeal this particular type of order to the High Court. The court also pointed out, interestingly, that the controller had actually kind of messed up too by treating the review application almost like a fresh patent application and conducting a whole second hearing, especially since the appellant hadn't really shown valid grounds for a review in the first place, like finding new evidence or a clear error on the record.
So from a strict legal standpoint, the appeal shouldn't have even gotten off the ground. But did they still look at the merits of the invention itself just in case, or did they stop there?
No, they went further. They explicitly stated that even setting aside the maintainability issue, they scrutinized the merits anyway. And they found that the application would have failed regardless on substantive grounds.
Okay, so what were those substantive grounds?
They identified several fundamental issues. Firstly, a clear lack of sufficiency of disclosure under Section 10.4. Even if they accepted the idea of needing a PI team, experts in AI, black box modernization, object-oriented design, the court found the disclosure simply did not sufficiently enable anyone to actually make or use the claimed product, method, or means.
They said it merely coalesced existing literature, I remember reading. What did that imply for actually building this thing?
It implied that while the inventor gathered a lot of information from existing patents and articles about harnessing AI, the specification crucially failed to provide specific directions on how to adapt known technologies for his specific concept of persona extension and augmentation. For instance, black box modernization prior art showed that was used for updating outdated information systems. The application didn't explain how to apply that technique to, augmenting a human persona via a necktie.
Right.
The court concluded that trying to work the invention based on the description would require undue levels of experimentation and even inventive faculty from the skilled person or team. That's far beyond what a patent disclosure is supposed to demand. They cited the No Fume Ltd case here, a precedent that says a patent spec needs to lay things out clearly, not make the reader invent it themselves through excessive trial and error.
Okay, so not enough how-to. What about the best mode and the clarity of the claims? Those concepts seem particularly abstract in the inventor's arguments.
Absolutely. On the failure to disclose the best mode under Section 10.4b, the court looked at those claims describing the CSOA and the decussation of pyramids, the inventor's stated best mode. They found these lacked workable criteria. The specification mentioned using standard object-oriented analysis and design techniques, but gave no practical teachings or examples of how to actually use them for the claimed integration. And the whole decussation part, relying on biblical and natural element analogy, critically lacked any technological enablement. It just wasn't technical enough. They referred to the C. Vanderlilly NV case, which stresses that the best mode disclosure has to be practical, not just a theoretical idea.
Got it. And the overall clarity.
Yeah, that was another big failure point. A significant lack of clarity, conciseness, and fair basing under Section 10. The court found the claims themselves to be lengthy, vague, and often used unintelligible wording. They concluded that the descriptions of persona extension, augmentation, and black box modernization, taken together, did not represent a workable embodiment for actually achieving the invention's stated goal, super-augmentation and global governance via wearing a necktie. It just didn't hang together technically.
Didn't meet the standard for clarity then.
No. It failed the legal criteria, citing the General Tire and Rubber Company case, which says claims need as clear a definition as the subject matter admits, and Biogen Inc., which requires the specification to enable someone to perform the invention across the full scope of what's being claimed.
So the language was just too abstract, not concrete enough for a patent, even for such a, visionary concept. What about the persistent objection under Section 3K concerning computer programs? Did the court agree with the patent office there too?
They did. On non-patentability as a computer program per se under Section 3K, the court found the invention did not possess any technical effect, nor did it demonstrate any impact on hardware. They echoed the patent office's point. While black box modernization techniques were known from prior art for legacy information systems, the application offered no working examples or demonstration of the applicability of these techniques to achieve the claimed persona extension and integration. There was no bridge built between the known tech and the new application.
And they cited a case for that.
Yes. They cited Microsoft Licensing Technology LLC v. Assistant Controller of Patents, which really clarifies that the technical effect requirement in India means showing how the software interacts with hardware to produce a new result, or how it improves the underlying technology, not just being an abstract process.
So given these fundamental failures on sufficiency, clarity, and technical effect, they didn't need to delve into the other objections.
Exactly. The court explicitly stated it found it unnecessary to examine the other objections, like the one under Section 3B about morality or 3-meter about mental acts, or even the basic lack of inventive step under 2.1. The invention failed on such fundamental grounds already.
So just to recap the legal framework, what specific precedents and statutes did the court really lean on to reach these conclusions? What was their main legal toolbox here?
Well, the core statute was definitely the Patents Act, 1970 itself, especially sections like 3K on non-patentable subject matter, 10.4 on sufficiency and best mode, 10.5 on clarity, and Section 117A, which defines the routes for appeal. They also briefly touched on the Civil Procedure Code regarding the review provisions.
And the key cases.
As we mentioned, no fume LTD was important for the undue experimentation point. See Vander Lully NV for the need for a practical best mode. For claim clarity and fair basing, they relied on the General Tire and Rubber Company and Biogen Inc. And for that crucial technical effect requirement for computer-related inventions, the Microsoft Licensing Technology LLC case was key.
In a case this complex, dealing with such, well, imaginative ideas, was there any disagreement from the bench? Did any other judge offer a different perspective or a concurring opinion?
No, it seems not. The judgment was delivered by a single judge, Mr. Justice Senthil Kumar Ramamurthy, and the record shows no mention of any dissenting or even separate concurring opinions. It was a unanimous decision from the judge hearing the case.
Okay, so what does this all mean then? Stepping back, what's the legal significance or maybe the broader message from this whole deep dive for innovators, for patent law, especially in these rapidly evolving fields like AI and augmented reality?
Well, I think this decision is significant on several levels. Firstly, on a purely procedural level, it really underscores the strict interpretation of appeal routes in Indian patent law. It clarifies that these specific review orders under Section 710(1) Health are generally not appealable to the High Court under Section 117A. That's important clarity for lawyers navigating the system.
Right, a practical point for practitioners.
Definitely. Secondly, and perhaps more broadly relevant for innovators and for you listening, it strongly reaffirms the requirement for a tangible technical effect for computer-related inventions to be patentable in India under Section 3K. It sends a clear message. Abstract ideas, algorithms, or even just applying known techniques in new domains isn't enough. You must demonstrate a clear, concrete impact on hardware or a real improvement in how a technical system works. It can't just be a concept existing purely in software or theory.
So the how is critical.
Absolutely. And that ties into the third point. This case serves as a really crucial reminder about enablement and clarity. Even wildly conceptual or interdisciplinary inventions, like this super-cyborg idea, must be described with enough detail and clarity for that person skilled in the art, or maybe even a team of them, to actually implement the invention without needing to do more inventing themselves or undertake undue experimentation. Vague language, metaphors like the necktie, or even, biblical references, however creative they might be, are just not substitutes for clear, precise technical disclosure in a patent application.
Okay, so if you had to distill it down, pick just one key takeaway from this entire fascinating legal saga of the super-cyborg, what would it be for our listener?
I think the single most important key takeaway is this. Groundbreaking, even seemingly beyond AI concepts, must be grounded in precise, enabling technical details and demonstrate a concrete technical effect to win patent protection. Visionary ideas alone, however brilliant, are simply not enough for the patent system. They have to be described in a way that allows someone skilled in that field to actually make and use the invention without needing to figure out the inventive steps themselves.
That really highlights the tension, doesn't it, between this kind of boundless innovation, the really out there ideas, and the very practical nuts and bolts demands of intellectual property law. It shows even the most imaginative concepts have to be firmly rooted in technical reality to get that legal protection.
Precisely. The whole legal framework, it's designed to promote innovation by granting these temporary monopolies, these patents. But the trade-off, the price of admission, is that inventors must clearly teach the public how their invention actually works. And this case really throws up an important question for you, the listener, to maybe think about. As technologies like AI, augmented reality, and whatever comes next continue to push boundaries, maybe even into more abstract realms, how do you think patent law should evolve? How can it balance protecting truly novel, perhaps even quite abstract concepts with maintaining that fundamental need for concrete technical enablement?
Yeah, that's a great question. What stands out to you from this deep dive? Maybe think about how this decision might shape the future of patenting these cutting-edge technologies. How do we make sure that brilliant, unconventional ideas aren't just stifled by the system while still maintaining the integrity and clarity that the patent system needs to function? Lots to ponder there. We'd love to hear your thoughts.